Hi, hello everyone. My name is Mohammad Nuruddin Mansoor and my student ID is DY20404. Today's presentation is in scope of business and corporate law, and in this presentation we are going to discuss about offer of contract, and we utilize IRAC framework to demonstrate the present context of Ming's Hair Saloon alias Australian Airlines. Applying Iraq method in this session, we address issues, rules, application, and conclude the scenario given in Ming's case. Present scenario: Ming's decide to promote his business by advertising a special offer in the local newspaper, which in turn offers a haircut as low as $10. A day past the advertisement published, Ming had as high as 50 people approach the salon to claim $10 haircut. Ming is overwhelmed with the response and realized a potential loss in revenue. If these promotions goes on, Ming had displayed a new sign outlining the offer of haircut as advertised and has now finished. Also, there is an indication that $10 haircut can be claimed upon producing the advertisement published, but there are 10 customers who have not held an advertisement. We now discuss any legal obligations that may arise with the agreement of advertisement. Issues are as below. First one, whether any legal rights are available to the 40 customers who have comes to Ming's shop with the advertisement. Second one, whether any legal rights are available to 10 customers who did not bring the newspaper advertisement with them to Ming's shop. Third one, whether any legal obligation is owed by Ming toward those 50 customers who have come to the shop for getting a haircut for $10. Fourth one, whether Ming has the right to eliminate the offer which is posted on the newspaper by displaying a sign in the shop. One of our team will take from here and provide you an insight on contract and the obligations associated. Thank you.
Hello everyone, this is Mansoor and my student ID AB2754. I'm going to discuss about what is a contract and legal obligations that are attached to any agreement. A contract creates a legal obligation between the parties based on which they have to adhere to the terms given under the contract, or else they could face legal consequences. The parties to a contract have the right to enforce the other contracting parties to comply with the terms given under the contract. However, this is not an absolute rule. Khalil and carbolic smoke ball case, this is relevant in this matter since an expectation is given in this case. Application to the scenario: the advertisement posted by a Ming is a unilateral offer rather than a mere sale puff. This offer can be accepted if the customers compel with the instructions which is to bring the newspaper with them to the shop. The first 40 customers have adhered to this element based on which they have entered into a valid contract with Ming. In case of 10 customers, the instructions are not met. They have not bought the advertisement with them and they can't legally enforce Ming to get a haircut for $10, and Ming cannot revoke the unilateral offer just be putting a sign in his shop, and the offer can be revoked unless the performance has started or did not complete within a reasonable time. One of our teammates will take from here and provide you a detailed conclusion for this scenario with the information provided. Thank you.
Hi everyone, my name is P. Sai Ganesh Gaur and my student ID is ISV2202. I am now going to discuss about legal obligations of Ming's case in detail and provide a brief note of the company incorporation and its consequences. It is clear that there is a valid contract in place for the customers who comply with the conditions expressed in advertisement. To conclude, a valid contract has formed in the case of 40 customers are abided by and complied. The 40 customers have entered in a valid contract and they can get a haircut for $10. Other 10 customers cannot since they did not comply with the instructions. They failed to produce the advertisement published. Ming is obligated towards people to give them a haircut for $10 since a unilateral offer is made by him through the advertisement. He is obliged to offer $10 haircut to the customer who produced the advertisement published. The offer cannot be revoked by putting a sign in the shop. This would be breach and false representation. So now we would wish to wrap up the concept of offer of contract and move on to discuss the complaints associated to registration of a company. We in detail discuss about the distinction between the public and proprietary business corporation. We shall also cover the difference between small scale and large scale proprietary companies and the level of business activity involved in order to determine the position. Using Iraq model, we discuss on a given scenario to establish a low cost brewing of espresso coffee company where few family members are involved. You want words Anjok coffee to be included in company name to have a local advantage. One of our teammates will take here to provide a detailed information on compliance associated with ESIC in regards to determine the nature of business. Thank you.
My name is Nia Sheikh and my student ID is BSI2303. I am going to discuss about Corporation Act. The Corporation Act 2001 is a key legislation for companies in Australia. As per this act, there are two main types of corporation incorporated in Australia, which includes public and proprietary company. Public company has the authority to issue its shares in the public for purpose of raising capital for its operations, whereas proprietary company did not have the authority to raise capital by issuing its shares in the public. The public company is further categorized into company limited by shares, unlimited liability, liability by guaranteed, and no liability company. The policies which a proprietary company has to comply with are relatively fewer than compared to public corporation, which have to comply with regulations such as continuous disclosures, lodging of annual reports, reporting requirements, appointments of auditors, and others. A proprietary company can be categorized into both a small and large as given under section 45A of the Act, provided that the number of members is limited up to 50 non-employee shareholders. In this case, two of the following conditions are fulfilled. Then it will be a small proprietary company. The corporation has revenue of less than 25 million in a financial year. Its gross assets are less than 12.5 million in a financial year. The number of employees hired by the company is less than 50 if a corporation satisfies any two of three conditions in a financial year, and then it will be considered as a small proprietary company. Furthermore, my mate will discuss about this task.
Hi, this is Harisesh Anil Kumar Singamneni and my student ID is DY26281. I'll be taking further from my mate. I'll be discussing about the large-scale proprietary companies. If the following conditions are fulfilled, the conditions are in a given financial year, if a company reports a revenue of $25 million and also reports a gross assets of greater than 12.5 million, the company also hires more than 50 people in a financial year. In this case, the conditions are satisfied as per compliance of ESIC, and this will be considered as a large proprietary company. In the case, a proprietary company should be registered with ESIC. During incorporation, the structure provides various advantages to the parties that compared to public companies. The parties will be able to raise capital by issuing shares to the public. However, the legal complexities will increase the challenges and overall cost of operations. Therefore, the legal regulations of the company will increase as well, as since it had to comply with the disclosure and reporting requirements along with lodging of annual accounts and appointment of an auditor. While choosing the name of the company, prior permission of ESIC is required. The reason for that being a company exists with similar name, and it shows the relationship of the company with government of Australia and New Zealand, which could mislead people. Okay, I'll I'll explain this case in the present context. So Anzac Coffee is an economical way of producing coffee at home. So they want to start a business. In the first year of business, they report gross assets of 5 million and they have 20 full-time employees with a gross revenue of 10 million. In this case, we will consider this as a small proprietary company given the financial data provided. So in 5 years, the company is aiming to stand at a $13 million gross assets and employs 5 full-time employees and more than 66 part-time employees, and the gross revenue is equal to 26 million. So in this case, a proprietary company should be registered with ESIC as a large proprietary company. As a large proprietary company, and especially in this case, as using Anzac name, they need to seek a prior approval from ESIC, considering the rules and regulations associated with ESIC's framework. Okay, we will conclude our session. Hopefully, this is a helpful session for every one of us. Please do let us know if you have any questions in this. We are happy to help in this regard. And this presentation is now finished.